Hey, beautiful people, and welcome back. In business dealings, there's a golden rule of thumb that says, he who provides a number first loses. We all know courts are businesses, and these rule of thumb transfers as though it's just regular business. When you bring any claim against someone, what you want is you never yourself want to be quick to settle outside of your intent to sue, which shows that you've afforded them due process and exhausted your remedies. And they will play hard. Now, they play hard because they are banking on the fact that most people who sue municipal entities or their representatives in private capacities are incompetent. They bank on that, and they expect that. And they expect and intend to create res judicata's to use in the future against those to be coming. It's what a bully does. Once a bully does something over and over consistently and sees that he or she is efficient with it, it becomes food. They become better at it, and they want to keep doing it until someone comes out and nips it in the bud. The way that you want settlement to occur outside of intent to sue, which is just your ability to show that you've done good faith. As the case is going on, presuming you got everything going on right and you know what you're doing, you don't want to interrupt the proceedings and offer a settlement demand just because time has been stretched out or because you feel like you got the case in the bag and, well, we might as well just end it. Never do that. What you want is you want the acting judge, which is the referee, aka the neutral third party, to come in and propose a settlement, because now everything that acting judge does is always going to be in the form of a court order, and that court order is what's going to be used to back up that settlement offer rather than merely being your words. Because remember, as the plaintiff, you are the claimant. The case is yours. And if you are the plaintiff, the claimant, the acting judge would always lean to your side a little bit more if you know what you're doing. And when that happens, when you see the clue, when you see that opening, when you see that weakness, take it, run away with it, and put it to use. I'll be playing to you an audio of exactly how it looks like. Settlement, the active process of settling, the act of bestowing or giving possession under legal sanction. That's what settlement is. It has to be a legal sanction, and that legal sanction is that court order. Bestowing or giving. Giving what? That which is rightfully yours. Or restoring to you that which is rightfully yours. The sum, meaning monies. Estate, meaning interest. Or income, meaning monies. Secured to one by such settlement. When you're secured, you have effectively won. When a settlement is made, it is equivalent to a judgment saying that, hey, you pay this guy this amount. Meaning now you can take that settlement offer if they don't want to perform after the case is closed. You really know how to be a secure party beyond just carrying the title around. You can monetize that. You can use that as an asset. But usually they won't be that stupid if you push them to that point. So here's an audio of exactly what it would usually look like and what the demeanor of the acting judge would be towards you.
For us as well.
So I'm going to
And
make
this
it
is
six,
Alex.
not three. Yeah, I'm going to make it six, not three. Mr. Bay is way more on the ball than your average or even your above average pro se litigant. But things usually take a little bit longer when there's somebody who's not an attorney on one side. So to have people at least exchange proposals. I'm going to ask Mr. Bay within the next 2 weeks to make settlement proposals to each of the defendants. And Mr. Bay, I'll leave it up to you. It's your case. It's completely up to you whether you want to make it a global settlement proposal for everybody together or whether you want to make separate proposals to each of the defendants' counsel. And you should just do that by letter to them. No need to file anything with the court. That's 2 weeks from now. So we're going to put in the order plaintiffs to make one or more settlement demands or make settlement demands to the defendants by
For us as
Now, pay attention to the fact that he just made it clear that that settlement demand should be outside of the court proceeding. At this point, they've been getting their ass handed to them. And that's their way of saying, we don't want any more of this, and we don't want this to turn into a case law. So just go to them again privately and just get rid of this case, please. Is basically what was just said. And this ended up in a $15,000 paycheck. Now, it might not be a lot to some, but for a 6 months worth of work, it's all right. It's not too bad. If time permits, and in the future, we'll be going over how you structure that settlement check to make sure that they accept it, to make sure that you don't show any form of weakness or any haste, or waive your substantive right that you've worked towards for that past 6 months. I'm not sure how long it's going to take for you, but whatever the period of time you've built up to this point, we'll be going over in the future how to structure your settlement check. There's a lot of different things that's to come. When the time comes for this, they'll be dealt with. But nonetheless, this is what you want in any given court case. You want them to submit. And of course, they're never going to always say, hey, we submit. And you want that submission to be by court order. Remember, a court order is a money order. At this point, we all should know that court is bank. And so the same state of mind and the same concept that occurs in bank or accounting, and when it comes to finance, is the exact same thing that goes on with court. So whenever a judge writes an order, if it has anything to do with money, either a form of judgment, either some form of forfeiture or settlement, that is a money order. Because now you can ride that all the way home. If they refuse your settlement offer, you can show, look, it's the neutral third party saying this, now you're in dishonor. That is presuming you've been handing their ass to them prior to this. If you come right, the acting judge would even let them know, look, this guy is above average. It's probably in your best interest to settle because you're not going to get too far with him. So just go to each other on the private. Don't even put in a court record. Don't make it look like, you guys are coming to an accord. Just go privately and get it done, and stop disgracing yourselves in the public, and just give this man some money, and so he could just shut the hell up and leave us alone. Until next time, best of luck.